Good evening. We were back calling to order the October 9th, 2019 meeting of the Ascension Parish Zoning Commission. All members, with the exception of Mr. Dumas, are present tonight. We do not have staff introductions, but Ms. Jamaica, go ahead and introduce yourself so we have it on the
Jamaica
record.
Banker, Zoning Secretary.
And we'll go over to staff. Cody, you're still here. We know that.
Lance Rock, zoning official.
Eric Poche, Parish Planner.
Jerome Fournier, Director of Planning Development.
And we have, item number 3 is a motion to approve or deny the minutes of the October 14th, 2019 meeting, moved by Mr. Christie, second by Mr. Chasson. All in favor?
Aye.
Any in opposition? Hearing none, motion passes. Item number 4 is the chairman's comments, which the chair's comments the chair will not comment tonight, other than what he already has. Item number 5 is a public hearing to amend the Ascension Parish Development Code for recommendation for the approval or denial to the Ascension Parish Council. Item number 5A, zoning review ID PZ 2081.19, conditional use for telecommunication tower for Vaughn Monroe, application submitted by Tillman Infrastructure, AT&T, located on the south side of River Road, approximately 150 feet east of Brassett Road, to request a conditional use to construct a new telecommunication tower. Staff. It was a mouthful.
Great. Yeah, the applicant is requesting a conditional use for a 242 feet telecommunication tower. It's a total of 250, which is the maximum height with the lightning rod. Basically, he's asking for a conditional use. He has submitted information to the parish. He's submitted everything that he needs to submit. But I also want to put in that state that he's asking for a variance because the code requires that the tower be 100% plus 30, the tower from any dwellings or structures. And the tower is within structures, and I think there's a site plan in there that states that he's within that, so he's asking a variance for that.
We can't grant the variance, so that's something the council would have to grant.
No, sir, you can grant that.
Okay.
But they're making stipulations to account for it, correct?
Yes, sir, that's correct. There's fall zones and those type of things that's in there. Yes, sir.
All right, we'll go ahead and open a public well, actually, is anybody here on behalf? Yes, sir. Please come up and.
Good evening, Mr. Chairman, Board. My name is Tony Phillips. I'm with Fullerton Engineering, representing Tillman. Address is 1100 East Woodfield Road, Schaumburg, Illinois, 60173. As Lance pointed out, we're proposing a cell tower on Mr. Monroe's property. AT&T is working with Tillman Infrastructure to locate towers near sites that they already exist, which they're close by. They gave us a search ring of X amount of feet. In this case, I think it was 2,000 feet, to find something suitable for them to go on, because the current tower owners have been kind of giving them an economic hardship, if you will. They're making it difficult to get things approved. Anytime they want to add additional equipment to the tower, there's like a toll booth. Every time you touch it, they want more money, and rent goes up. And so AT&T has determined that over the course of the life of the lease, in some cases, it could be almost $1 million, that rent that they could save by going with another tower company. As you know, most jurisdictions have a co-location requirement saying, okay, well, if there's an existing structure, you need to go on that. And the tower owners know that. They know that the codes are backing them up on this and creating this monopoly. It's like saying there's one gas station in town, and you can guess what's going to happen to the price of gas if there's only one gas station. Well, if there's only one tower that they can go on, the tower owner then has free will to charge whatever they want, because they know the jurisdiction is backing them up with the code. So AT&T is trying to find locations close to their existing site, because they have to supply the same coverage to their clients, to their customers. They can't just take it away. And in some cases, they may choose to take it away. Their leases are expiring, and before their leases expire, they're trying to look at their options. And one of their options is to relocate onto another tower, especially a tower owner that is more, let's just say the terms are a lot more agreeable. They're not going to charge them every time they touch the tower. They'll have a fixed rent, there'll be escalations, but it won't be, a crapshoot every time you try and do any kind of technology. In addition to that, AT&T is proposing this FirstNet program. They're working with the government to provide a FirstNet program, which is a first responders network, which is a clear channel for first responders, where if there's any kind of emergency, if every time there's something bad happens, everybody gets on their cell phone. Well, if everybody's on their cell phone, the first responders have nowhere to go. So this network would be a dedicated network for first responders. So this is, in addition to, this is one of the things that kind of triggered a lot of this, is because they're looking to add this equipment and they're trying to keep the costs down. So, at the end of the day, if the costs keep going up on the tower, what's going to be passed down to the consumer? Or they may just say, you know what, we're not going to pay that. We'll just keep things the way they are, and we're not going to change our technology. Or they may remove it completely. And so we're trying to, help them find a location. Now, this site in particular was one that they gave us a 2,000 square foot search ring to contact property owners in that area so they could provide the same coverage to their current customers. And Mr. Monroe was open to entertaining that. He was one of the property owners that was contacted. And his site, we know, is a little narrow, but the fall zones, when you're doing ordinances for fall zones, technically the fall zone is because, the setbacks for tower height is for the fall zone so it doesn't hit something, right? Well, if we have a tower that will collapse on itself, we have in your package, you'll see there's a statement from the engineer that's designing the tower that the tower will fold in half on itself. It's designed to break at a point. If there's stress on it, it will just come down. The antennas will be up at the top, and it'll, slap down on itself, and basically taking away the need for that fall zone or the tower setback. So, if anybody has any questions, that's pretty much it. So we're just asking for, obviously, the zoning, the conditional use, because it's not permitted in that zoning district. So we are requesting a conditional use permit to put it in that spot, and then obviously the setback variances.
Thank you, sir. We'll go ahead and open a public hearing on this. Ms. Jamaica, has anyone signed up to speak?
Yes, Mr. J. Wendell Clark.
Mr. Clark?
Yes, sir.
Reminder, you have 3 minutes, sir.
Thank you, sir. Wendell Clark, I'm here on behalf of SBA Communications. That's the company that has the present tower that AT&T is operating on. And we're here to address some of the allegations in the application that are incorrect and very vague and don't really provide the information that's supposed to be provided. As the board knows, the parish code clearly provides a priority for existing co-location towers rather than new single-use towers. And the application requires specific information about why you can't use an existing tower. All that AT&T and Tillman have said is that they want to be able to provide 5G and FirstNet and other technology, and that the rents are way higher than they should be. I have an affidavit from a representative of SBA that makes several important points. First of all, SBA entered into an agreement with AT&T in October last year for AT&T to add FirstNet to their tower, and it's up to the carrier to go to put the equipment in place, and they've never done it. So it's not like they've been prevented from what they're asking you to be able to do on the existing tower. They also, as Ms. Kitchens points out in her affidavit, all of the technology that they say they need to be able to have for 5G and other uses is available on this tower, the same as it would be for the Tillman Tower. And finally, as far as the rent issue is concerned, nobody has ever complained to Tillman about, to SBA about the rent. When they negotiated the contract to add the FirstNet equipment a year ago, they didn't complain about the rent. There weren't any problems with the rent. My client has reached out to them about other service issues and whether they need anything from SBA. They've never brought up rent or any other problem. The situation here is that your code provides a priority for the existing tower. And unless they can demonstrate a real need and a real reason to need a new tower, then it shouldn't be approved. And so again, I have an affidavit that I'd like to provide to the commission. I have a picture of the notice that was put on the property that doesn't give any information about what this meeting is for and that it will involve construction of a 250-foot tower. And so for purposes of the record, I'd like to note that there may be more people here to comment on this if the notice had been adequate. So I'd like to submit these, if that's okay, Mr. Chairman.
It is okay, and it will be submitted and accepted. Is anybody else signed up to speak, Mr.
No.
All right, we'll go ahead and close the public hearing on this. Any questions or comments from the
Yes,
commission? Mr. Berman?
yes, staff, is the design that the first speaker mentioned, has that been submitted to parish and approved as a
No, sir, it
approved
hasn't
design?
been approved yet. It'll go through this process, and then if it gets allowed for the conditional use, then at that point, he'll permit it.
So it'd have to be a variance, I guess, of some type to allow that, to consider that.
That condition has to be approved by the zoning commission.
Mr. Schexnayder, you had any questions or comments?
I think I usually do.
Well, I thought you said you did.
I'm
If you
sorry.
don't, I'm
You had
okay
that
with
look on
that
your-
too.
you had that look on your face.
No, the only real question I have is that do we have anything in the code that prevents just somebody wanting an extra tower just because they want to have it? If they wanna sign a lease for a certain piece of land and they want to put an additional tower, do we have anything against that in the code?
They would have to come back. I mean, they would have to come back if they want to put another tower on that property. That's what you're talking about.
Well, in
No.
other words, we're talking about, there, we have an existing tower. AT&T is, want to work with Tillman to put in another tower. Whether or not they have a lease or anything like that, do we have anything in the code that specifically states you can't just put another tower?
No, sir.
Okay.
No.
Yeah, it's
Yeah, it doesn't say you can't put a new tower, but it has the considerations that you guys need to consider when a new tower is requested.
172043D,
That's what
page 40.
What does it mean, Cody, when it says priority given to co-locations of communication antenna by more than one provider on existing new telecommunication towers shall take precedent over construction of a single-use telecommunication pa-
That would be antennas. So that'd be co-locations of antennas to be located on it. So the towers can hold multiple antennas on the
for
tower.
multiple networks.
So we allow co-locations for them to change these antennas out as the technology changes or whatever may change.
But I'm wondering the priority that's placed on existing towers. Is there, what's the standard for,
It's the page before, it's section D, 1, A and B, and then 2. It's the page right before if you've got your code book, it's page 46.
When seeking a building permit for a new tower location, the applicant must provide the following information to the director. A, the location of all towers, buildings, and other structures which could serve as a platform for telecommunications antennas within a 2-mile radius of the proposed tower site. B, a full explanation outlining the reasons that the proposed telecommunications antennas cannot be placed on the towers, buildings, or structures listed. This explanation must be given on each structure individually. And then subsection 2, if the inability to secure a suitable lease arrangement prevents a telecommunication antenna from being placed upon an otherwise suitable tower, building, or structure, the points of disagreement, including but not limited to the proposed lease payments, must be provided to the director. And then 3 was the subsection you read with the priority given co-locations.
so I guess it's our decision,
Yeah, it's your
or
discretion, it's your legislative
ultimately, it's the parish council's decision as to whether or not.
discretion. No,
Be
that's
yours.
with y'all.
It's yours.
And then any appeal from you guys goes to the Board of Adjustment. for
Correct.
final decision.
Correct.
Gotcha.
But if I'm reading this correctly, so we would need the explanation, full explanation outlining the reasons why these antennas can't be placed on the existing tower. And if the reason is that because the inability to secure a suitable lease arrangement, then they must provide all the points of disagreement, including the proposed lease payments. Have they done that?
I can address that.
Yeah, you can address that, please do, sir.
Couple of things here. to provide the same coverage to the residents and the workforce of the parish, we're limited to a certain search area, 2,000 feet. So within the 2,000 feet, yes, the existing SBA tower is there and AT&T is already there. If they were to come off, then there would be a gap in the coverage. So they want to stay in that area. So that was one of the reasons why we selected that. Regarding the hardship, the economic hardship, and disclosing all the terms, that's not something that any one of these cell phone carriers would want to do, because the minute those terms of leases come out and become public record, then that could cause a firestorm of, you have no idea, because every landlord is getting different money. Every tower, the ground landlord is getting a different amount of rent than the guy next door and the guy next door to him. So the last thing they want to do is make that public record. But I do have, we can provide a hardship letter from AT&T saying that they have, basically what they're asking for is the same terms that Tillman is willing to offer them. And because their lease is coming up, they're looking for, better terms. And if Tillman if SBA is willing to match the terms that Tillman is offering, they have no problem with that. But it hasn't been evidenced yet, and enough so that they're asking Tillman and myself, and they're spending money to send me down here to represent them. There must be a reason. If everything was hunky-dory, they wouldn't be looking to move off of this tower. So that's what we're looking at.
I guess my issue on this is the conundrum that we face as a commission here, because this isn't a court of law. Nobody's sworn in. We have an affidavit that's been put into the record, but there's really no cross-examination of that. And, I can see where one party could say, look, these terms are not agreeable to us. We don't like them. And we need to move off and do something that's more economically feasible for us. And I really, when I was listening to these discussions, I'm thinking, why are we listening to this? It should be something a judge or a jury should be listening to, as the terms of a contract and whether somebody complied with it or not. So I'm not sure exactly what the standard is, but I think that it sounds to me, from what we've heard and what's in the packet, that there is cause for us to approve this ultimately, and if something else works, and if there's a breach of contract issue, that's not our area of expertise or jurisdiction, I don't think, but.
Well, I think another precedent set is what I mentioned earlier. If parish does not approve the design, that the structure cannot fail from the base at the ground and fall and hit something 250 feet away, and his design that he mentioned, it snaps in the middle, it's not accepted. I don't think we can consider that.
Well, I would agree with that. We would have to
Right.
grant the variance of the new tower.
Right.
I'm not an engineer either, so
No.
I'm assuming that what you're telling me is true, that this tower, if something does happen and it collapses, it will collapse within, so that will not endanger any other
But I think-
structure around it.
but I think that's for
It
the
has a
parish
great
to
point
approve.
that where the antenna, the heavy part would fall on the
Right.
tower itself.
Right.
That's
And if the
great
parish would approve that, then that would be something to consider, but since they haven't approved it, I don't think we can.
The parish isn't gonna approve it until he gets his approval for him to build the tower. He's gonna have to submit
Y'all are allowed to-
engineering
Y'all are allowed to put
drawings to
conditions
state
on the
that.
approval. So if you want to put a condition of, approval of the engineering
Mm-hmm.
design by parish consultant, you can do that under
Mm-hmm.
the code.
Any other questions and/or comments?
I guess,
Chairman, may I have one other comment?
I will, since it did a little bit different than a public hearing, but that being said, we're not a court of law, but I want you to have your.
I won't abuse your courtesy, thank you. This is really not a contract issue, though, Mr. Chairman. It's about interpretation of your code, and the request for this new tower is a location that's within a half mile of a tower that is serving AT&T. They've represented to you that they can't get the service that they want without this tower, and we've given you information that they're being provided that service. They've represented that they don't like the rents, but they've not given you any substantiation for it. I've given you an affidavit that says they've never come to us to negotiate rents. So they can't explain to you what the points of disagreement are because those have never been explored. And so they want to move to another tower, whatever their reason is, but they're not in compliance with your code because they haven't done what's supposed to be done under your code. And there's a priority for the existing tower.
Right, and I understand what you're saying, and what I see here, and I am a lawyer, so I do know somewhat about the law, but what I see here is an issue, a factual issue, as to whether or not there's an issue with the rents, whether or not, and you two are passionate for your positions, and I get that, but it's hard for us to decide, well, this side is more credible than that side, and I really we can't do that. I mean, because there's no witnesses here, nobody's sworn in, nobody's subject to cross-examination. All those things that would say, well, this is a legitimate complaint versus it isn't. And that's the problem that I have, that we're being put in this position almost to make that determination based on representations of representatives, which I represent people every day in court, and I've never heard the court say, well, I'm just going to accept your version of facts with nothing else. And so I'm not taking one side or the other. All I'm saying is that they've made a representation as to certain hardships that are there. I'm assuming that they're being forthright about it, just like I'm assuming that you're being very forthright in saying, well, these hardships really aren't there. And it's positions that it's hard for us to get to the bottom of what is actually the fact there.
One difference. No one from AT&T has said that they've tried to negotiate the rents. I've told you that they haven't.
Yeah.
And so there's a gap there, and I'd suggest to
I think
you
he's
that-
disagreeing with you.
that they should
And I don't think it's
be
something we should
required to
consider.
do
That's
that.
not for us to consider. that.
Well, except the code specifically states that if the inability to secure the suitable lease arrangement is what's requiring them to put up the new tower, then they're required to propose all points of the disagreement, including the proposed lease payments, which he's indicated he's refusing to do. Under the code, for us to consider it, he has to put forth
Okay.
the proposed lease
Okay.
payments. That's, I
Under
mean,
that
that's,
particular section, but I would caution you, Mr. Chesson, or at least explain that, look, you don't read D1A and B together with 2, because I think there's two separate provisions. So if he's gonna make the argument that the lease payments is the reason they need a new tower, then I agree with you. Subsection 2 applies, but don't, you can still grant it under subsection 1A and B. You see what I'm saying? They don't tie together.
well, but one is because they can't place the antennas onto the other tower, onto the existing tower. He never said they can't place the antennas, the proposed antennas onto the existing towers. That's what one has to
I
deal
don't
with.
disagree with that statement. I would just tell you, don't read them together.
Right. Well, but if it's under one, he has to show that he can't place the proposed antennas that are gonna go on the new tower onto the existing tower, which I don't think he's shown. If he's gonna go under 2, he has to show what the points of disagreement are, including the lease payments. And then 3 says priority is given to the co-location, which would be to put all the location of all the towers, or all the antennas onto the existing tower.
Now, I would tell you, watch how you read that one, because the way I read it is you give priority to towers that are gonna handle more than one provider. I don't know, did they give you that information? Is this new tower gonna be for more than just AT&T?
Yeah, and they didn't,
For 3 carriers.
All right, any other comments? I think we've kind of gone round and round, or does somebody have a motion on this, one way or the other?
I'll make a motion to deny, or recommend denial, or whatever
All right.
we have
A
to do.
second.
Let's be clarifying on this. So we don't need to worry about the variance if we're going to recommend denial of the tower to the council,
Correct.
correct? Okay.
But not to the council, you guys are the decision makers.
Right. Whatever your
With an
decision,
appeal
if
allowed.
they'll have a option or to
Okay,
appeal.
I want to be clear on this, because the agenda says we're having a public hearing to amend the Ascension Parish Development Code for recommendation for approval or denial to the Ascension Parish Council. So we're not making a recommendation then to the council, this is a final
That must be a
decision for us?
paragraph or whatever, but
That's correct. Yes, sir.
Okay, then the agenda needs to be made clear in the future, because it says 2 different things. All right, so we have a motion to deny on the table, Second by Mr. Chasson, seconded by Mr. Furman.
Yes.
All in favor?
Aye.
Any in opposition? I hear none in opposition, so the zoning request is denied. I'm sorry,
I
sir.
just have one thing to say. There's a reason SBA sends a representative here.
I understand.
They have a lot at stake here. And
I-
if you were to approve this today, this could trickle down across the country,
No, I don't think that was lost on any of us. I think we got that.
okay? So just, you just granted them the right to have the only gas station in town. That's all I'm saying.
All right, staff report.
No report.
Do I have a motion to adjourn?
Motion.
Meeting adjourned. Thank you all.